Two things I want to talk about this month. That's dispute resolution in the listing agreement, the arbitration section. And I also want to talk about commissions mentioned in the purchase contract. So firstly, let's take a look at the listing agreement. In section 12 of the listing agreement, the standard ERS 18 TB, or the single agent one if you use that, it talks about the agreement should be construed under Florida law, and any controversies or claims under this should be dealt with firstly by arbitration. And it's been generally taught in the past to sign that with the seller and then have the broker sign to agree to all go to arbitration. The problem with that is if we go to arbitration and we are definitely in the right, there is no way that we can reclaim our attorney's fees in arbitration. Whereas if we go to court and we know we're definitely in the right, then we have an opportunity to claim our attorney's fees. So my advice is that you don't initial the arbitration clause in paragraph 12, and therefore you allow yourself, if there's a dispute between the brokerage and the lister, the seller, then we can go to court rather than go to costly arbitration. I welcome questions on that, and you can text or email me at any time. Secondly, I want to talk about line 632 in the as-is contracts. Line 632 is right at the end, and that talks about commissions. And it's an instruction to the title agent, the closing agent. It says, you cannot vary commission that's offered in the MLS by anything written in the purchase agreement. Now, I'm sure most of you know this already, but I just want to clarify because I keep seeing commissions being reduced or added to in the additional terms of the purchase contract. Well, that's not going to cut it. So if you remember, the commissions are earned by the brokerage. They're offered by the broker of the listing agent, and they're earned by the broker of the buyer's agent. And the only people that can vary that are the brokers. And how we do that is by a letter. So if the buyer's agent says, I don't want any commission in this deal, I want to give it all to the buyer, we don't put anything in the contract. We ask for a letter to be sent from the other broker to us, and then we submit that to the title agent, who then can abide by line 632 of the contract, where they're told, no, you can't vary the commission by the contract, because they now have a letter allowing them to do that. So two important things: arbitration in the listing agreement and varying commissions in the purchase agreement. If you want to vary commission, it's a letter from the broker of the other side or your broker from this side sent to the title agent agreeing to vary the commissions offered in the MLS. Have a great month.